Have you recently received an IRS notice of deficiency and not sure how to get rid of this problem in a legal manner that provides the benefits you're seeking? Have no fear. This is a specialty area for Weiss+Associates. We are located in continental Europe and have successfully dealt with this problem on behalf of more than 500 clients. What we mean by success is that each of our clients who meet our strict criteria have received a U.S. tax court order of dismissal for lack of jurisdiction. With this U.S. tax court order, the IRS threat of a notice of federal tax lien for the year in question is defeated. Jurisdiction. The first aspect in addressing the IRS NOD letter is a focus on jurisdiction. There are two separate and distinct jurisdictions in regard to the application of the federal income tax and having a successful outcome over the IRS. Those two jurisdictions are, 1, the Constitutional Republic, meaning the 50 states of the Union, and 2, the District of Columbia and U.S. territories and possessions. By the way, most federal statutes and regulations created by the U.S. Congress only apply to this jurisdiction. Everyone should realize quickly that the District of Columbia is not a state of the Union. The District of Columbia is a foreign jurisdiction to the Constitutional Republic. The national government has incorporated many of the same terms that are used to describe the Constitutional Republic, meaning the 50 states of the Union. Do you think this is a coincidence? Not a chance. Some of the identical terminology used by the national government is found in such terms as United States, U.S. citizen, person, and trade or business. If you are not careful to distinguish the statutory expressions used by the national government in your everyday use of those terms, you will be misled very easily. You should look up in Black's Law Dictionary these terms, as well as in the Internal Revenue Code at Section 7701, the definition section, and compare what you find there with the meanings you use every day for those terms. One unique feature about this foreign jurisdiction is that the Constitution has no legal effect upon the national government within its limited jurisdiction. That is not a misstatement. If you enjoy relaxing by watching television programs with themes based on lawyers and police shows, you perhaps have noticed the dialogue referencing the distinction and limitation of federal jurisdiction. By reading the 16th Amendment, it is clear that the federal income tax is only lawfully applicable in the District of Columbia. All you have to do to see this fact is to read the actual 16th Amendment. You will find that the U.S. Congress ignored the rule of apportionment as required of them in the Constitution at Article 1, Section 2, and Section 9. Still, many Americans have unwittingly volunteered to allow their income to be taxed like that of a U.S. resident alien who are true U.S. taxpayers. This is how the national government has gotten around the constitutional requirement to adhere to the rule of apportionment. Most Americans, unfortunately, do not understand the full impact of jurisdiction correctly. The 16th Amendment ignored the rule of apportionment. Thereby, the only proper application is to that unique jurisdiction that is the District of Columbia, because the Constitution has no full force and effective law within the District of Columbia. Former President George W. Bush said it clearly when he stated that the Constitution is just a blankety-blank piece of paper. Think about this for a moment. The 16th Amendment to the Constitution avoided a constitutional requirement to incorporate the rule of apportionment. The national government tried to levy the federal income tax upon Americans back in 1894, and shortly thereafter, the U.S. Supreme Court declared any income tax directed at Americans in the constitutional republic to be unconstitutional without the use of apportionment. Before we get involved in some detail about the NOD letter you recently received or are anticipating receiving, there is some additional background that needs to be presented in this discussion as established by a federal appellate court. In the 1972 case of Economy Plumbing and Heating versus the U.S., the federal court stated, "Revenue laws relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for non-taxpayers, and no attempt is made to annul any of their rights or remedies in due course of law. With them, Congress does not assume to deal, and they are neither the subject nor the object of federal revenue laws. For there to be both taxpayers and lawful non-taxpayers after reading the 16th Amendment, there must exist two separate and distinct legal jurisdictions, and this is where to look for clarification. There are actually two groups referenced by this federal court, a group of taxpayers who owe the federal income tax, and a group of non-taxpayers who have no legal obligation to file or pay a federal income tax. In fact, the court stated that this group is not the subject of federal income tax laws. The taxpayer group liable for the federal income tax under the 16th Amendment falls into the exclusive or sovereign jurisdiction of the national government. This is the group the IRS and the U.S. Tax Court has authority to regulate the public conduct of those so subject to this jurisdiction. These lawful non-taxpayers have unalienable rights, and the national government cannot regulate private conduct because to do so would violate the Constitution. Additionally, the oaths of office of those federal workers who would infringe on unalienable private rights would put them in jeopardy if they were somehow imposing by force the control of public conduct. The national government and its bureau, the IRS, are only able to impose the federal income tax within the District of Columbia via the 16th Amendment. So if you have a choice to be in either group, which one would you choose? For many Americans, that would clearly be the non-taxpayer group. Can someone be born into the taxpayer jurisdiction or volunteer to be subject to this jurisdiction, which permits the national government to regulate what is referred to as public conduct? The short answer is yes. For those who receive an NOD letter from the IRS, they must first be a U.S. taxpayer as identified in the statutory laws created by the U.S. Congress. Those humans who are legal taxpayers, called U.S. citizens, must be born within the District of Columbia or any of its U.S. territories or possessions. Those who are legal non-taxpayers, as referenced by the federal court, were born in the constitutional republic, by birth to parents of at least one of those were born in the 50 states, or by naturalization. Instead of using the statutory term U.S. citizen, as the national government uses, we eliminate all confusion by introducing a new non-statutory term, American national. Interestingly, the national government does not use the term U.S. citizen in their select statutes and regulations when addressing those American nationals within the constitutional republic. They have come up with a foreign-sounding term that most American nationals would never think about as being identified as such. That term is non-resident alien individual. If you think about it, this term has the elements that they need. Those not subject to the exclusive jurisdiction of the national government are in fact non-resident within the District of Columbia. Such American nationals are also alien to the statutory and regulatory laws created by the U.S. Congress when such laws, like the 16th Amendment, apply only within the jurisdiction of the District of Columbia and no place else. For many of you listening now about this portion related to the NOD, you have just experienced a paradigm shift. It may take you some time to study this material if you are open-minded enough to make the effort to verify our statement on our own. You should start with 26 CFR section 1.871-1A and 1.871-1B4. We will not go into detail on those subsections of this regulation, but it is a great place for you to start your own effort. You will understand it better by reading the legislative intent of the 16th Amendment, which is available for download on our website, Weiss+Associates.com. Our objective is to keep this as simple as possible for such a complicated subject. Time to take a look at what an NOD is and explore some options about addressing it that may be new to you. The first topic to understand is to ask questions such as, how did the IRS arrive at this point by issuing an NOD? A notice of deficiency letter is referencing a type of IRS enforcement threat toward those the IRS perceive to be within the public domain, in which they will seek to control the public conduct of those subject to the jurisdiction of the national government. All IRS enforcement actions, such as assessments, liens, and levies, are based first on the filing of a Form 1040 income tax return. If you sent in a Form 1040 claiming to be a U.S. taxpayer, then the IRS has every right to come full steam at you to collect money you were saying you were willing to pay the national government. If that is the case, then for that year in question in which you filed a return, you owe the money. No further discussion on this subject is of any value to you for those years in question. However, if you did not file a Form 1040 for the years in question listed on the NOD, then that presents an altogether different process that will be worth listening to a little longer. It is important to know that while some statements are truly stated, that such statements may or may not be statements of the truth. For example, if I said, I have over $60 billion, is that a true statement? It is in one sense, and that originates from the fact that I made the statement. Please understand, just making the statement does not make it true. We all know that, but sometimes we don't think too clearly. We know this could be said of what you are currently listening to today as well. That is why you should start checking out the facts from us, or anyone else for that matter. Just because one is sincere does not mean they are sincerely correct. So we encourage you to make the effort and read the information provided on our Resource Center referenced on our homepage. Okay, so back to the NOD at hand. If you did not file a Form 1040 U.S. individual income tax return or a variant of that form, then the IRS claims that under 26 U.S.C. Section 6020B and 26 CFR Section 1.6020B that they have the authority to create a substitute for return, an SFR. That is what is truly stated by the IRS. While it is true that the IRS makes such statements in their Notice of Deficiency about authority to create an SFR for a Form 1040, that does not make it so. In fact, when you read the Internal Revenue Manual at Section 5.1.11.6.7, Authority, you will find 8 forms that the IRS does have SFR authority to create such a return. Noticeable by its absence is any reference to authority for the creation of a Form 1040 return. Care to guess how an NOD arrived when you did not send in a Form 1040? You probably guessed correctly. They created an SFR for a Form 1040 without any specified authority whatsoever. You might want to look up in Black's Law Dictionary the word fraud. A fraud imposes no duty and imposes no obligation. An IRS fraud is a violation of the oath of office of the party who created it, as found in their appointment affidavits. A fraud is an illegal act designed to trick you into doing that which you would not choose to do otherwise. So, if you did not file a return for the years in question stated on the NOD letter, the IRS was guilty of fraudulently creating an SFR for a Form 1040, which later leads to a fraudulent assessment, which resulted in a fraudulent deficiency notice. Keep in mind, if this is your situation, then you can address this matter via the United States Tax Court. We can provide assistance to get this IRS fraud addressed properly with the USTC in your behalf and get this issue dismissed for lack of jurisdiction. The second thing to understand is to uncover facts by a simple question. Are you one who is a U.S. taxpayer? Remember the Economy, Plumbing, and Heating Declaration by the federal court, in that there are those who are and those who are not U.S. taxpayers. If we can determine those who are U.S. taxpayers, then those not listed have to, by default, be those who are lawful non-taxpayers. U.S. taxpayers are 1. Those who hold a public office and derive income that is effectively connected with the conduct or performance of the functions of that public office, called a statutory trade or business at 26 U.S.C. Section 7701A26. This is confirmed by the legislative intent of the 16th Amendment, written by former President William H. Taft on June 16, 1909, and published in the Congressional Record of the United States Senate on pages 3344 and 3345. 2. U.S. resident aliens. Those who fit this description are from a foreign country and choose to live and work in the District of Columbia or even the 50 states of the Union. Foreigners have no benefit or protection under the Constitution and are considered as property of the national government. This is clearly referenced at 26 CFR 1.871-1A. 3. U.S. persons. These are legal fictions and also include those who are statutory U.S. citizens as defined at 8 U.S.C. Section 1401A. Those U.S. citizens born have to be born in a territory belonging to the United States, i.e. the national government. They are subject to the jurisdiction of the United States, the District of Columbia, and are under the dominion and control of the national government, which means Congress. 4. Those who derive income from sources within the United States, the District of Columbia, via 26 U.S.C. Section 861A. such as interest from bonds, notes, and other interest-bearing obligations of the government, dividends, rentals and royalties, personal services performed in the statutory United States, disposition of United States real property interest, sales or exchange of inventory property, Social Security benefits, and guarantees of indebtedness if effectively connected with the conduct of a trade or business in the statutory United States. 5. Non-resident alien individuals who made a voluntary election. These are the American nationals we referred to a while back. However, these people had to have elected to allow their earnings to be taxed under 26 U.S.C. section 6013 G or H, like that of a U.S. resident alien. All of these are U.S. taxpayers. The IRS has a perfect right to come after you if you don't pay your fair share of what they perceive you owe. Do you see yourself described here as a U.S. taxpayer? If so, then you should and must pay that tax. Look again at the list. And do you understand which category you fall within if you are a U.S. taxpayer? Earlier we mentioned the term non-resident alien individual. You can find the definition for it at 26 U.S.C. section 7701 B1b. This is where you have to start thinking about statements being truly stated and statements of the truth. Here's the stated definition for a non-resident alien individual. An individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States. What have you just learned? Only what a non-resident alien is not. The U.S. Congress never stated what a non-resident alien actually is. Thus, if you are what we refer to as an American national, or what the U.S. Congress refers to as a non-resident alien individual, you have to be one who is a non-taxpayer, as stated by the federal court in the economy, plumbing, and heating case we referenced in the opening comment. There are simply no other groups of people in the world other than American nationals who fill this niche as referred to by the U.S. Congress. Think about this. All foreigners who live in their native country aren't subject to U.S. tax laws. Thus, they are excluded from this conversation. All foreigners who desire to live and work in the Constitutional Republic or the District of Columbia, including any U.S. territories and possessions, are immediately U.S. taxpayers. They are referred to as U.S. resident aliens, so we know that this group is not describing American nationals. Those who are born in either the District of Columbia or any U.S. territory are statutory U.S. citizens. This does not include those who are American nationals. Thus, we can now exclude this group in trying to identify just who are non-resident alien individuals. The only remaining population left is the roughly 300 million American nationals living and working in the Constitutional Republic. Now let's take a look at the liability for the federal income tax for those non-resident alien American nationals as stated by the U.S. Congress. A quick look at 26 CFR section 1.871-1A will reveal much for your understanding about any federal income tax liability. First, it addresses the fact that resident alien individuals are, in general, taxable the same as citizens of the United States. That is, a resident alien is taxable on income derived from all sources, including sources without the United States. So you see that foreigners who elect to live and work in the 50 states of the Union or the District of Columbia are legal U.S. taxpayers per the U.S. Congress statement. For a review on what a U.S. citizen or citizen of the United States in a statutory sense is, review item 3, U.S. person in the list of U.S. taxpayers. For clarification, there is the statutory reference to the term United States that needs to be addressed. You will find the statutory meaning of this term at 26 U.S.C. section 7408D, citizens and residents outside the United States. Here you will see that all references in the Internal Revenue Code, unless stated expressly to the contrary, mean only the District of Columbia. Here is what is stated there. If any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for purposes of this section as residing in the District of Columbia. Perhaps we should return to our discussion about the tax liability of non-resident alien individuals. Again, still looking at 26 CFR section 1.871-1A, you will find stated, non-resident alien individuals are taxable only on certain income from sources within the United States and on the income described in section 864C4 from sources without the United States, which is effectively connected for the taxable year with the conduct of a trade or business in the United States. Wow, we needed to break that down some for a real understanding. Let's try to see if our translation will make that statement by the U.S. Congress a bit clearer. Non-resident alien individuals, American nationals, are only taxable or liable for the federal income tax if they derive income from sources within the United States, or better stated as the District of Columbia, and from sources outside the United States, or better stated as outside the District of Columbia, which is effectively connected for the taxable year with the conduct of a statutory trade or business in the United States, or better stated as the District of Columbia. So now you see that the non-resident alien individuals have never been made liable for the federal income tax by the 16th Amendment unless they make a voluntary election to allow the government to tax their income like that of a U.S. resident alien. Here's the following section at 26 CFR section 1.871-1A that shows this fact. However, non-resident alien individuals may elect under section 6013G or H to be treated as U.S. residents for purposes of determining their income tax liability under Chapters 1, 5, and 24 of the Code. By the way, we have discovered a legal method created by the U.S. Congress to vacate or terminate the voluntary election that you made years ago. The Congress had to provide this in order not to violate the 13th Amendment in regard to the abolishment of slavery and involuntary indentured servitude in the constitutional republic. Thus, there is no federal law imposing the federal income tax upon non-resident aliens, only unless they make the voluntary election to be taxed. Then that changes their status as they go from one who is a non-taxpayer to one who is a U.S. taxpayer. This brings all the statutory laws into effect, and the full weight of the national government is imposed upon them by the simple act of making an election to grant the national government the authority to lord their tax upon them. You have to go to 26 CFR section 1.871-1B4 to learn what a non-resident alien actually is. The outcome of this discovery is that Americans born in the 50 states of the Union, or those born to parents of which at least one was born in the 50 states, or an American who has become so by naturalization, are actually non-resident aliens to the jurisdiction of the national government in Washington, D.C. The essence is that Americans, as expressed above, are what we refer to as American nationals. This is a non-statutory term that we created to stop the confusion with the term U.S. citizen. It is clear that American nationals are those not made liable by the 16th Amendment, and so declared in 26 CFR section 1.871-1A, unless they make a voluntary election to allow the national government to tax their income like that of a U.S. resident alien. The U.S. Congress has tricked American nationals into converting their status in order to tax them when the laws of the land prohibit such, as expressed in the legislative intent of the 16th Amendment and 26 CFR section 1.871-1A via a sub silentio act. After all, the District of Columbia is a unique enclave, a city-state much like that of Monaco. In this jurisdiction, the Constitution is null and void. It has no full force and effect of law, but most Americans think of this federal area as the nation's capital. It is a foreign jurisdiction to each of the 50 states of the Union. Most of the laws passed by the U.S. Congress apply only within the District of Columbia and have absolutely no impact on the 50 states unless such laws are published in the form of an implementing regulation in the Federal Register. Such proof of that publication would show a volume, date, and page number. It would be far simpler if the U.S. Congress were to write the jurisdiction on the top of each piece of legislation they create, so that the average American national could more easily discern the true jurisdiction to which a bill or act of Congress actually applies. Can you imagine what that would do to the power and control of the U.S. Congress if they told you with each law what the jurisdiction is that can only apply toward? Ask about the Patriot Act, the Military Commission Act, and so on. Find out what jurisdiction they actually apply toward by seeking the volume, date, and page number of their publication within the Federal Register. While you're at it, ask the U.S. Congress about the jurisdiction to which the 16th Amendment is actually applicable toward. The legislative intent of the 16th Amendment tells you the answer in the event the U.S. Congress chooses not to do so. In summary, if you are a U.S. taxpayer, as you have seen in the presentation so far, then you should and must file and pay that tax. If you are an American national, or non-resident alien, as the U.S. Congress prefers to address those born in the constitutional republic, who for any reason filed a Form 1040 years ago, that election was established. This is an annual, automatically renewable event for those who have done so. But there is a solution available, and we have that documentation for those who seek our services. Remember, to continue your participation in the U.S. tax system, you must file a Form 1040 or some variant annually before the IRS can send you a notice of deficiency letter for not filing a return for the year in question. The IRS has no lawful authority to create an SFR for a Form 1040, but they still do it fraudulently and send that fraudulent claim in the U.S. mail to over 22,000 American nationals monthly when they choose not to file any longer. The IRS will not listen to any legal arguments, as they are basically bill collectors. Thus, one can only resolve this conflict the IRS created in their NOD by taking it to the United States Tax Court. This is where we can begin to assist those American nationals who did not file a return and are now facing a notice of deficiency based on a fraudulent SFR for a Form 1040. This procedure includes a 100% money-back guarantee, meaning that if you qualify as a candidate for this procedure and follow all the directions correctly, we guarantee you will receive a court order of dismissal for lack of jurisdiction from the U.S. Tax Court or get your money back. You do not have to hire an attorney or personally appear in court. This procedure only requires the sending of our correspondence through the U.S. mail. This will have to be done by you. In order to be an eligible candidate for this procedure, you must, 1, not be a federal employee or official in any capacity, or be a U.S. resident alien. 2, you must have received an NOD within the last 150 days. 3, you must not have filed any income tax return for the years in question listed on the NOD. And 4, you must not have had any prior correspondence with the U.S. Tax Court for the years stated on the NOD, nor have you filed an amended petition or paid any filing fee. If you meet all 4 of these strict criteria, then you qualify for this procedure. This procedure normally takes the U.S. Tax Court about 3 to 4 months in order to issue the dismissal from the time you initiated the first letter. Remember, the IRS has 2 enforcement actions available to them to impose their tax claims against you: liens and levies. The notice of deficiency you have received is the initial correspondence toward a notice of federal tax lien action. Like any enforcement action, the NOD has a reasonable time frame to respond if you wish to challenge it. The NOD provides for a 150-day period from the date on the NOD you received. This is about 5 months' time, but we implore you to get started immediately. Remember, the quicker you start, the quicker you will receive your dismissal and get this issue behind you. However, keep in mind, the IRS may also attack you through a levy process for the same years in question that you received the dismissal. So it's possible you may have to defeat them twice in U.S. Tax Court. The levy process will be discussed in a separate video, but if you receive one of these, you have only 30 days to respond. Either way, please go to our website immediately. You need to email us the entire NOD in PDF form, along with a phone number to contact you. We will personally discuss your options and payment arrangements via PayPal through either a phone conversation or email. Also, if you want to obtain specific references to federal statutes, regulations, or Supreme Court decisions, please email us and specify exactly what you are looking for. Many documents are available for download on our Resource Center. Thanks for listening, and please contact us through our website, Weiss+Associates.com.